get started in just a little bit once we've got everybody in the group. To start off with, everybody's going to be muted, but if you've got questions, you can put them in the Q&A section, not the chat, but the Q&A. And that way we can field them as they come in. Looks like we got 33 people so far. For those of you who are joining by phone, if you're not viewing the computer screen and you're only listening on your phone, you won't be able to see the documents that Chris is going to cover. So if you do have the ability to jump on your computer and join that way, I think it'll be a little bit more interactive for you. If not, if you're joining by phone and you do have a question at any point and you don't have access to the Q&A button, you can send that via text to 980-505-1926. That'll pop through on my cell phone and I can ask that. But that's just for those of you who are joining by phone and you don't have access to the chat feature. Again, that number is 980-505-1926. We are recording today's webinar, and a link will be shared later today by Katie Chapman with Charleston Apartment Association. She's on with us as well. And then we'll also post it on our firm's YouTube page. The documents that Chris is going to cover, we'll share the links in the chat a little bit later. I'm not going to do it too early because I don't want us to get ahead of ourselves. And but once we get those posted, you'll be able to copy them and save them and download whatever you need from there. So looks like we've got a good bit in. So, and it's 1:02, so let's go ahead and get started. For those of you who don't know me, my name is Michael Bell. I'm the Director of Client Relations with Loebsack Brownlee. We've also got Katie on the phone with us. You all know Katie's on with us. She's with the Charleston Apartment Association, and most of you know her. And then, of course, Chris is going to be our host, Chris Loebsack with Loebsack Brownlee. He's the managing principal of our firm. So I'm going to let Chris take it away. Just a reminder, we are recording it. So if you have to drop out, you'll be able to watch it online later. If you've got questions, down at the bottom of your screen, you should see a Q&A button. Please be sure to post questions in the Q&A rather than in the comment section. And we'll take it away.
Thank you, Michael.
I waited till you got a mouthful of soda.
Yeah, that was good. Excellent time. Well, good afternoon, everyone. Thanks for joining us here in my, I feel like, I don't know if anyone has been watching the late night TV host, but Jimmy Kimmel Live is doing his show from his living room. And it's pretty funny. I'm starting to feel that way because my little recording studio here is outside my office and it's literally just a room with just this stuff in it. So every time I'm starting to get the feeling that I'm like Jimmy Kimmel and I'm just talking to an empty wall. And I can only see Michael in my feed, so it's literally like I'm having a conversation with Michael, and that's it. So anyway, little humor. The COVID day 8 million seems to have kicked off with a bang for everyone. So so today we're going to spend the next hour-ish talking about the recently enacted CARES bill that everyone has been hearing about. I'm sure you've all been having many conference calls about what to do about it, how to deal with it. And so we're going to start with that, and then we're going to kick, after we go through the statute itself, we're going to spend some time talking about an NAA best practices guidance document that came out just recently last week. And I think it's really a great resource for everyone to refer to. So we're just going to go through the resource document together so that everyone can see what the best guidance is from NAA. I can explain to you why that's what their guidance is, and that way hopefully everyone will walk away both with a copy of the document in case you don't have it yet, but also be an understanding of why the document says what it says and what that means for you and your properties. So, without further ado, as always, if you have questions while we go through it, feel free to shoot them in the chat. Michael and I have developed a pretty good workflow where he can interrupt me at a good spot. If he sees a question that's relevant to what I'm talking about, he'll chime in and I'll answer it while we're going. Okay, so the CARES Act was enacted Friday, March 27th, and it went into effect immediately upon being signed by the president that evening. The section that's relevant for our conversation is the moratorium section. There's, it's a 600 page document. So there's plenty of sections and plenty of other things to talk about. But for our purposes in the multifamily business, we want to talk about this one, section 4024. That's on your screen now. It's called Temporary Moratorium on Eviction Filings. What it says is, it starts off with definitions like most statutes do. And the first one is covered dwelling. What dwelling is covered by this section, in other words? And it means any dwelling, residential, that's occupied by a tenant pursuant to either a lease or a verbal lease, someone without a lease, where it's terminable under state law. So any residence that is being occupied pursuant to some sort of lease, verbal or written, and is in or on a covered property. So covered dwellings are, in many instances, an apartment rented to a tenant that's located in a covered property, which is an apartment community. So then you go to number 2, what is a covered property? Which properties are covered? And this is the one that's super important. A covered property means any property, whether it's a single family house or a multifamily building, that participates in a covered housing program. Those are defined in Section 4141 of the Violence Against Women Act. It's federal law. Or it participates in the Rural Housing Voucher Program under Section 542 of the Housing Act. Those are pretty specific issues. Or it B, has a either federally backed mortgage loan or federally backed multifamily mortgage loan. So that is a super important distinction. Those are the 2 items that are really most important for most everybody. Section A of the covered property definition basically says that if your property participates in a federal program of some kind, then you are covered. If you're a Section 8 program, if you're low-income housing tax credit, if you're rural housing voucher program, or any of a number of other program-related properties, those are all covered. If you're a federal program, obviously the federal law covers you. But it also goes on, B is important because it says that any property, even a regular property that doesn't participate in any government programs, is still covered under this statute if it has a federally backed mortgage loan or a federally backed multifamily mortgage loan. So, of course, then we have to figure out what is a federally backed mortgage loan. That's item 4. Federally backed mortgage loan and federally backed multifamily mortgage loan are essentially the same. It's just that one of them applies to a property that has 1 through 4 families, and the other applies to any multifamily property building that houses more than 5 families at a time. So, the truth is, if you have a quadplex, in other words, then you still have a multifamily building, but it only applies to 4 families, and so that would be a mortgage loan. If you have a building that has more than 5 units or more, that makes it a multifamily building, and so you're looking for multifamily mortgage loans. So over the last week, since this act went into place, your companies, all of you who manage multifamily properties, have received emails from our firm advising that we need to know whether or not your property has a federally backed multifamily mortgage loan, because we need to know whether your property is covered by this statute so that we will know whether or not you are subject to the moratorium or whether you are exempt from the moratorium. So when you hear that we are asking, do you have a federally backed mortgage loan, this is why. So a federally backed mortgage loan or multifamily mortgage loan is defined as one that is A, secured by a first or second lien on residential multifamily real property, designed principally for occupancy of 5 or more families, and is made in whole or in part, or is insured, or is guaranteed, is supplemented, or assisted in any way by any office or agency of the federal government. So that is the very large, very broad definition that they chose specifically for the purpose of capturing as many multifamily communities as possible in this net. They want the definition of who is a covered property to be as broad as possible. They want as many apartment communities in the country to be covered by this moratorium, which is bad for you, good for the residents, and good for the government's agenda of trying to help people who are sustaining problems with COVID by casting a broad net, prohibiting lots of actions under this statute. So in order to know the answer to this question, is my property subject to a multifamily mortgage loan, you really have to go directly to the lender. Only the lender would really have the specific level of knowledge to know for sure whether or not that loan or any of the loans are made in whole or in part, guaranteed, supplemented, or assisted in some way by the government, whether it's Fannie Mae or Freddie Mac or HUD. Those are super broad opportunities for the government to capture you in their definition. And so you really do need to look to the loan officers themselves, and perhaps the CFO of the company that is insured would know because they probably were involved in the loan process. But you really are looking to the lenders themselves to make sure you know this decision. But by and large, colloquial evidence indicates that somewhere in the neighborhood of 70% of all multifamily communities appear to be subject to, covered by this definition. We may find out that it's not quite that high, but as of right now, our early returns on this project seem to indicate that it's somewhere in the 70% of all multifamily communities are covered. Of course, there's a number of apartment communities that are owned outright. The mortgage was paid off and the company is held on to the property, and so it's not subject to a mortgage at all. If that's the case, then you're not subject to the moratorium in these cases. But if you have a mortgage on the property, you have to go through this complicated analysis to know the answer. Okay, so on to the moratorium. Definitions are done. We know what properties might be contained. What's the moratorium say? That's section B. So if you read section B, it says, during the 120 days starting on March 27th, the lessor, the landlord, may not do the following things. So let's start with that. 120 days from March 27th is July 26th, or 25th, technically. So between last week and July 26th, you can't do any of these things. That is no joke. 4 months. A, you may not make or cause to be made, i.e. hire a lawyer to, file with the court of any competent jurisdiction, initiating a legal action against a tenant to recover possession of a covered dwelling from that tenant based on or for as a result of non-payment of rent or non-payment of other fees or charges. One more time, during the 120 days from March 27th to July 25th, if you are a covered property, which 70% of them are, you may not file any non-payment of rent evictions. None. I'm not kidding. 4 months. And it's actually worse than that. We'll get to that in a second. Also, on to number 2, you may not, from March through July, charge fees, penalties, or other charges to the tenant related to their non-payment of rent. So that would include late fees. You may not charge any late fee of any kind at any time, no matter what your state law says, no matter if you're in South Carolina or North Carolina, even though South Carolina says that late fees are rent, that doesn't matter because that fee, that charge is, whether you call it a late fee or whether you call it a charge to the ledger, doesn't happen unless they don't pay their rent on time. And that means that it is a charge that you're assessing to the tenant related to their non-payment of rent. That makes it illegal. That makes it unlawful, even in South Carolina. So starting March 27th through today, April, May, June, July, you may not charge any late fees to any resident at all if you are a covered property. It also means that if they try to pay you rent and their payment of rent bounces, you probably cannot charge them an NSF fee because that would be a charge to the resident that is related to their non-payment of rent. If they try to pay rent with a check or with an electronic payment and that payment gets returned, you can't charge them those fees either. Now, We'll talk some more about those in detail as we get into our white paper or our guidance document from NAA, but keep that in mind. Next, I said earlier that the 120-day moratorium for evictions is not just 120 days, it gets worse. Here's where it gets worse. Section C of the Act says, notice. You, the landlord, the lessor of a covered dwelling unit, meaning you, may not require the tenant to vacate that covered dwelling unit before a date that is 30 days after the date you, the lessor, provide the tenant with a notice to vacate. So as we go through the moratorium, you're not allowed to tell someone as we get into July that they have to get out and that you are filing an eviction against them on August 1st. Because you have to give them 30 days notice. So basically, when we get to the end of this moratorium, you're going to be required to send people a letter that you never have had to send before, because this law is creating a new obligation that doesn't exist. It does now, it didn't before. And that says that you have to have a 30-day demand. More importantly, item 2 says you can't issue that notice until after the 120 days have expired. So the first day you can send residents a letter saying that you have 30 days because you are behind in your rent and you have 30 days to get out. The first day you can send that letter is day 121 after March 27th, which is July 26th. Happens to be a Sunday, but I imagine a lot of our clients are going to be working that day for exactly this reason. That 120-day notice, or 120-day period, the moratorium period, means that at the end of the 120 days, you still can't file evictions in August because you're not allowed to send this notice until July 26th at the earliest, and you have to wait 30 days before you can initiate any lawsuit for recovery of the dwelling, meaning eviction. So what that really means is that the first day you'll be able to file an eviction at the courthouse if you are a covered apartment community that has a multifamily, federally backed multifamily mortgage loan. The first day you'll be able to file an eviction from today on is August 26th. Think about that. You have 5 months, almost, before you can evict anybody who doesn't pay you rent. And there's no ifs, ands, or buts about it. There's no end run, there's no shortcut, there's no loophole, there's no anything. If you have a federally backed multifamily mortgage loan issued by FHA, Fannie Mae, Freddie Mac, or HUD, you are not allowed to evict anybody who doesn't pay you rent until the end of August. It's not Easter yet. This is a big deal. You're not allowed to charge them late fees until the beginning of August. You're not allowed to file evictions actions against them until the end of August. Except, if you go back up, Michael, scroll back up just a little bit to A. Oh no, sorry, we're right there, never mind. We were where we need to be. Moratorium, except the definition of the moratorium says you cannot make or cause to be made any filing with the court of jurisdiction to initiate a legal action, an eviction, for recovery of possession of the covered dwelling from the tenant for non-payment of rent or other fees or charges. So the moratorium related cases. You're going to see from our firm a notice that's going to come out later this week. We're going to talk about this, but one of the things we're going to tell all our clients in an electronic news blast is, remember, this means you can't evict people who don't pay you rent. But guess what? People who have a habit of not paying you rent also have a habit of not following the rest of the lease either. They also have a habit of not honoring the authorized occupants paragraph, also have a habit of not honoring the authorized pets paragraph, also have a habit of not telling you they bring a pet in so they can avoid paying a pet fee or pet rent. They also have a habit of forgetting to put the utilities in their name or keep them in their name, like is required under the lease. People who don't pay their rent on time also have a habit of not getting renter's insurance when they're supposed to. They also have a habit of engaging in criminal activity. They also have a habit of getting into fights with their neighbors and yelling and screaming. They also have a habit of being boisterous when they think they have a leg up on you and tell you that you can't evict them, and they walk into the office disturbing your operations. All of those things are reasons you can evict them during the moratorium. And so one of our big pieces of advice is going to be, guess what? Time to start weeding out all the bad apples. During this moratorium, you should be filing on anybody who is creating a lease violation unless they are 100% current on rent. If they commit a lease violation, you are not prohibited by this moratorium from filing an eviction action for unauthorized occupants, unauthorized pets, creating noise disturbances that disturb the rights and comfort of other neighbors, for engaging in conduct in the leasing office that disturbs your leasing operations, for failing to keep utilities in their name. All of those are reasons why you can evict someone during the moratorium. The only one you can't is for non-payment of rent, which of course is the big one.
Chris,
My
we have
suggestion
someone
to
who
you
wants,
is-
sorry to
Oh, yeah,
interrupt.
go
We
ahead.
have someone who wants clarification on that. So the moratorium, is that only for covered properties?
Right. The moratorium only applies if your property is subject to a federally backed multifamily mortgage loan. If your property is owned outright, or if your property is financed with venture capital money, or if your property is financed by an insurance company, those are all things that we know exist as products that are alternatives to traditional federal mortgage loans. Sure, if you have those mortgages or those kinds of financing, or if you just own it outright, you are not covered by this moratorium. It does not apply to you, and you may engage in business as normal, including late fees, including eviction filings as usual. Yes. But for everybody else, non-payment of rent evictions are a thing of the past until August 26th. So you should dust off your lease documents and start paying attention to who's violating the other parts of the lease. And if they also happen to be behind in their rent, then maybe those are people you want to start evicting, because they're the only people you're going to be allowed to evict. And it's the only way you're going to be able to get rid of people that have a habit of not paying their rent on time for the next 5 months. So keep an eye out for that notice that's going to come out later this week from our firm in our usual electronic best practices bulletin. Michael and I are going to be working on that probably Thursday. Okay, so that's the moratorium. The notice provision is in there. You know the deadlines, you know the coverage, you know the limitations. So we're going to switch now to the NAA best practices white paper, guidance document, if you will, white paper. And this one was put out just a couple days later after the act went into place, and basically has been out all last week. You may not have seen it, and that's why I wanted to make sure we got it today so that everyone can see and we can go through this. Of course, it starts like any good white paper. It starts with a disclaimer that says everything that's in this document is not to be considered legal advice, and you cannot hold them responsible if you rely on it without consulting with your attorney first. So always the result there is always consult with your attorney if you have questions about what's in this white paper. But we're going to talk through it and go through each one at a time. So let's go to the overview part. It's down in the middle of the first page. In response to the COVID-19 pandemic and the financial hardships many residents are experiencing, NAA is working to assist its owners and managers with guidance on operations, especially related to resident collections. So the question we get all the time in the last 10 days is, well, how do we get people to pay rent if we can't file eviction actions and we can't charge them late fees? And the answer is you're going to need some help with that. You're going to have to get creative, and you're going to have to try and think of some things that are different. We also get a lot of questions about, do we have to use different late letters? And the answer is, of course you do. If your late letter says that you've now been charged a late fee and your property's not allowed to charge a late fee, you need to change your late letter. So you're going to need to consult with your counsel. Obviously, you know, what your late letter says isn't an eviction issue, so it's not something L&B would help you with, but our friends at Brownlee, Whitlow, and Prate, Thomas Howard and his colleagues are obviously the ones you would want to talk to, or we would recommend you talk to anyway, if you've got issues about, do I need to change my late letter? Yes, for sure. Talk to them and let them help you. Local, state, and federal authorities have introduced eviction moratoriums across the country in response to the coronavirus crisis that leaves many owners and managers planning for worst case scenarios. 5 months of many people not paying you rent is definitely a worst case scenario. It's important to recognize that the NAA, its affiliates, and individual members are not healthcare professionals. CDC and qualified officials should continue to be your primary source of information and guidance about healthcare issues. The NAA is offering this white paper as guidance for the industry, as well as insight and information that they've gleaned from officials and experts. So, guidance itself. Item 1, collecting rent. Obviously, you need to collect rent. You still have to pay for the building. You still have to pay your mortgage. You still have to make money. You still have to pay your employees. All those things mean that you need to keep collecting rent. That is not prohibited by the moratorium. Collecting rent is still allowed, thank God. NAA does highlight that you should recognize that some residents have been impacted by COVID-19. As of right now, you probably know plenty of people who have been laid off and furloughed and who are not yet receiving any of these magical promised unemployment benefits that everyone's state and federal governors and presidents have announced that they're going to be getting. But I don't know a single person that's gotten any of them yet, even though they started applying 2 weeks ago. Consider working with those residents or making alternate payment schedules, considering waiving late fees. You may have to waive late fees, obviously, as we just talked about, and providing financial resources to residents where applicable. What you want to do is, if you are a covered property, in other words, you need to recognize that you're not allowed to charge late fees at all. And so that goes by the wayside. Letting residents know that is an important piece of the puzzle, perhaps. But if you're also covered property, you also want to make sure that you are communicating to your residents that you have alternative arrangements. You should be working with residents. You should be, in South Carolina, taking all partial payments you can get your hands on at this point. You know, the law in South Carolina is very clear that you're allowed to accept partial payments, and you all know that. You've heard that from Thomas Howard many times in the past, I'm sure. In an environment like this, where money is everything, and getting as much of it in your till as you can is the ultimate goal here, partial payment acceptance should be a fact of daily life starting last week. And for sure should continue through the 150 days that you're going to have to wait before you can evict anybody. But making sure you tell your residents that is the other piece of the puzzle. Just because you do accept partial payments or are going to, not communicating that to your residents is probably counterproductive, because many of them are going to be impacted in some way. Many of them are going to have economic hardships of some kind to varying degrees. And so you're going to have people that would appreciate knowing that there is an alternative. And that will likely result in them bringing you what they do have. Whereas if they didn't know that you were going to accept it and they weren't aware that you were working with them and you had plans for working with them, they might choose not to pay anything at all because they know that they only have $700 instead of the $1,100 they're supposed to pay. And so maybe they don't even make the payment at all unless you have told them that it's okay and we want you to make the payment. We're willing to accept it in this challenging environment. Those are reasons why you want to have communication with your residents that tells them that it's okay to do things differently. This is a weird time and your residents need to know that. And even for people who aren't impacted by COVID, that's a matter to figure out as you go. There's plenty of people out there that don't have a financial impact yet, may not have one at all. They may have jobs where they're first responders, they're lawyers, they're doctors, they're still receiving their same paychecks, still working their same hours. And so the disease may not have any impact on them economically at all, but it may have a grave impact on them if they're a healthcare worker, socially and physiologically and or mentally. And those are real things. Just because they have their same paycheck doesn't mean that they have their same bandwidth to deal with getting their bills paid on time. And they may just simply need some grace. And so letting people know, even if they haven't been impacted, that you're willing to work with them, you're willing to talk to them. If they'll let you know what their challenges are, you can work with them. That's an important piece of the puzzle, is letting people know that there's all kinds of ways they can be impacted by this disease, and you're willing to work with them on all of them to try and help them through this. To prevent continued exposure, it would be great if you could do things that will encourage your residents to pay rent online or electronically if they can, so that you can minimize in-person contact, having to collect physical checks and whatnot. If you've closed your leasing office, or at least you've shut it to public access, it's open, people may be in the office, but they're not accepting guests and visitors, then a Dropbox or other method of money collection should be available for residents. So you may have to go backwards to the old Dropbox days if you've moved on and don't have a Dropbox anymore. Now may be a time where you want one. Employees should handle all money collection with disposable gloves and wash their hands accordingly. Healthcare advice 101. Make sure that you're doing that. The issue of putting a Dropbox out, if you don't have one now and you're going to add one for the next 5 months to make things easier, go backwards in time to your old advice and remember that Dropboxes are important to be secure. You should figure out a place to put them that is the hardest place you can think of where somebody could steal it or access it. Find some way to make the Dropbox a drop slot that comes through the door, whatever you can do to minimize the opportunity for vandalism, theft, or other ne'er-do-well activities, that would be really important. The last thing you want is to have payments in a time of crisis go missing by having them stolen by somebody else instead of ending up in your bank account where they belong. Okay, so let's move on to item 2. Item 2 is late fees. So the CARES Act, again, prohibits all properties who are covered properties from charging a late fee at all. But even if you're not a covered property, you may want to consider, this is in the best practices item, you may want to consider whether late fees are appropriate in this time, or at least at this moment in time. You know, this may be a rolling standard where it's not, you know, April may be one thing, maybe something, May might be something else, but June and July may be something else altogether. Who knows? As a courtesy, NAA provided they wrote up and provided a document called a Notice of Temporary Waiver of Late Fees. This form allows operators, even if they're not a covered property, to waive late fees incurred by residents who, as a result of COVID-19, are experiencing loss of wages, unemployment, or unexpected medical expenses. They have that form available. I believe it's in Blue Moon now as well, but it's also on their NAA COVID resources page for additional information relating to the form. As with all other NAA click and lease forms, please consult your local attorney before implementing the form into your leasing operations. Again, you need to make sure that whether you're a covered property at all in the first place before you consider having a temporary waiver of late fees. If you're permanently barred from having late fees because you're a covered property, then this might not be the form to use. But if you're not a covered property, then you might want to consider something like this on a short-term basis. And again, that's the kind of thing, like they say, you should consult with your local attorney, give Thomas Howard a jingle, let him help you figure it out. Item 3, payment plans. Many rental housing professionals already have individual plans in place to work with their residents during this unprecedented crisis, but many don't, or many are in the process of figuring that out. There is no one approach fits all. It is not a universal standard, in other words. The best strategy recommended by NAA is for owners, managers, and residents to partner together to find an optimal solution. As a courtesy, NAA also has developed and provides an NAA payment plan agreement. That's the COVID-19 pandemic form. It allows the resident who, as a result of COVID-19, is experiencing loss of wages, unemployment, or unexpected medical expenses to enter into a written agreement with you, the landlord, to pay their rent and other monies owed at a later date or on a schedule. Payment plans like this should be agreed upon by both the owner or management company and the resident affected. You can't have a very good payment plan if it's not reduced to writing on a form, whether it's this form or a different form. It doesn't matter technically. But if you don't have the payment plan reduced to writing, then it's going to be awfully hard to go to court in the months ahead and claim that the payment plan wasn't followed if you don't have a document that lays out what the plan was. So there's no way to have any faith in a verbal agreement done by a handshake in any way, shape, or form. You're not supposed to be shaking hands with anyone. But you can't do verbal agreements for these sorts of things. It's going to be too hard down the road to enforce them and to get the courts to uphold them. So whether you use the NAA's form or your own form, make sure you're using something and make sure that everyone's signing it when you're done, because there's also nothing worse than having a conversation, drafting a form, sending it to the resident by email, and then not getting it signed so that you don't know for sure whether they agreed to it or not. They may have had a verbal conversation with you, but when you sent them the form, they may not have agreed with what you sent. You want to make sure that everything gets signed and returned so that you have 100% confidence that you know what everyone has agreed to. Payment plans should be agreed on by both owners. All parties should sign a document. Visit NAA's COVID-19 resources page for additional information relating to their form. It's not approved for use in every jurisdiction. And as with the late notice or the waiver of late fee letter, please consult your local attorney before you implement those forms in your leasing operations. Everybody's company is in the middle of doing this as we speak. We get emails daily, almost hourly, about people trying to put their plans together. NAA has also fast-tracked the release of one aspect of its newest compliance, the click and comply. The rent relief form, which property management companies can utilize across their portfolio, will easily document and track requests from residents who are financially affected by COVID, including special arrangements or payment plans that have been agreed on by the property and the residents. The form It's free for 6 months and will allow property management companies to pull one report for each property, enabling an overview of the entire portfolio. And if you're interested in a form like that, they've got an email address here where you can reach out to Nicholas Tovar. He's the person in charge of that form. So when people come to you and are asking about utilizing the program that you put in place, whatever it is, whatever your program is, when residents reach out to you, there's some considerations you want to think about when you're conducting these individualized assessments. In other words, every resident who wants to have an agreement about how they're going to pay their rent in the months ahead during this crisis should have individualized attention from you. There doesn't need to be a one-size-fits-all answer here because, as I said, there are many people who don't have any actual economic impact at all from the COVID situation and are in fact making all of their regular payments, are receiving all their regular hours, and aren't suffering any economic harms at all. And those people don't need to be part of a COVID repayment plan because there's no reason why they can't pay their rent on time. But for folks who do claim to have an impairment, have been affected, whether it's medical expenses, loss of hours, unemployment, whatever it may be, these are some good ideas to keep in mind. A, did the resident lose a job or have the resident's working hours been reduced? B, can the resident provide some verification of that employment status change? Can they get a letter from their employer? Can they provide proof of loss of income? Can they provide proof of reduction in hours? You should ask them to do that. That's an important piece of the puzzle here. C, does the reduction in income put the resident below the typical 1/3 rent to income ratio? Is this going to really impact their ability to make their rent payment? You need to analyze that. You can't requalify them, of course. They've already been offered a contract. But if they've been reduced to the point where they're not going to meet your ordinary rent to income ratios, that's an important factor in deciding what is the appropriate way to help them. What kind of plan should we put in place for someone depending on how much income have they lost? D, another item that you want to consider, what other external factors related to the COVID-19 social distancing protocols are contributing to the loss of income? Are they a restaurant worker who is unemployed because they're not allowed to conduct restaurant operations in full and the restaurants are only operating as to-go orders right now, for example? That means that they very likely didn't lose their employment permanently, but only temporarily. Those are considerations you want to take in mind in evaluating what kind of program might this particular person need. Do they need a short-term workout payment? Do they need a long-term workout payment? Where are we? Item E, you want to consider, does the resident have an on-time payment history to start with? Are they a good paying resident under normal circumstances, or are they not? Have they been trouble from the beginning? That may be an issue you want to consider. And then also, you want to consider, should you ask the resident to suggest a payment structure they believe they could meet? Sometimes the most important thing you can do is asking the resident what it is they believe they can do, because if they tell you something, it increases exponentially the chances that they are going to try and live up to that. If you tell them what you expect, they may say, yes, I can do that, but if they don't really mean it, then it really won't matter because they'll end up in default down the road and you'll end up back in the same position you are now and you won't have any other agreements to rely on. So asking them what they can do really sort of triggers their personal connectivity to the solution. It causes them to be more inclined to want to live up to their end of the bargain because they're the one that suggested it in the first place. It may still not work. They may still be unable to do it, but the chances of them doing it are greatly better if you let them tell you what they can do and then you provide your response based on what they tell you. That helps a lot. Always the best. Don't tell the residents what you'll do for them. Ask the resident what they can do for you first.
Chris.
Yes.
Before we move on to the next one, we have a question on this section. If the landlord is allowed to accept partial payments anyways in South Carolina without jeopardizing the eviction, then why would they need a payment plan? What is the benefit?
The benefit of a payment plan is if you just got $500 from your resident and you don't know what their plan is with regard to the other $600 that they might owe, the payment plan provides some certainty. The payment plan allows you to anticipate what is to come. Whereas if the resident just drops the $500 off, you certainly should accept it, and that's great. But it doesn't give you any idea what to expect the other 600 or whether to expect the other 600. And so the benefit of the payment plan, or in this case, repayment plan, is that it allows you a better working understanding so that you can better budget everything off of what you anticipate coming down the road in the coming months. When do you think you'll be able to pay the other $600? How will you be able to repay it? Is it going to be in weekly installments of a little bit? Is it going to be in one big giant chunk? All of those things help you to better anticipate what's to come. Whereas if you just take their money and don't have any follow-up and don't have any payment plan and aren't allowed to evict them for 5 months, then not having the payment plan really doesn't help you at all. Taking the money is nice, but it doesn't, the payment plan is what provides some certainty to the relationship going forward. It provides additional coercive effect for the resident to want to honor their agreement to repay you, and increases the chances that you will get the other $600 down the road. Whereas if you do nothing, the resident pretty likely will assume that since you didn't do anything and you didn't say anything, maybe they can just not pay you the $600 and you're not going to say anything anyway, and they get off and you don't get the money. So I think there's value in doing it no matter what. Okay, on to item 4, resident communication. The most important thing owners and managers can do is communicate with your residents. In these trying times, lack of information is a killer, especially since you have lack of opportunities to communicate too. Now that your offices are closed, your residents can't even come in and talk to you about it, and so it really puts a premium on you communicating with them instead of waiting for them to come in and communicate with you. Ask residents to communicate with their property manager if they are unable to pay rent in full because of the COVID pandemic. Be proactive about this, in other words, is what NAA is suggesting. Don't wait for people to give you a $500 payment and then reach out. Have a plan that involves telling all your residents that if you are suffering economic hardship, let us know. Come see us proactively. Don't wait for them to make a partial payment and then try and get them to communicate. Tell them ahead of time that you want them to come talk to you. Because in a time like this, residents are worried. They are afraid both for their own economic well-being. They're also afraid of what might happen if they don't make payment. And so you providing encouraging communications to them is a big help. It will put them at ease that this is something that you are prepared to deal with and you are willing to talk to them, and it isn't going to be a problem. And that will hopefully allow more of your residents to feel comfortable coming and talking to you, which is what you really want. Consider asking affected residents to provide documentation from their employer that shows how they've been impacted by the crisis. But before you ask for that documentation, just be sure to check with your lawyers about what you're allowed to ask for if there's a special item in place in your local jurisdiction or your state. For right now, there isn't anything in South Carolina that has come out that would deal with that, but always check. And frequent and timely communication is the best course of action. Make sure that you keep talking to your residents. Don't just send one letter and hope for the best. Have a plan to send multiple communications in this time. Also, you want to make sure that your communications are compliant. And this is a big part where you deal with the Fair Debt Collection Practices Act. That overlays into this. In these scenarios, you have to remember that if your property is subject to the moratorium, then communicating with residents about all of your programs and other opportunities that you're willing to provide to people who are affected by COVID also requires that you be mindful of what you are saying to everyone at the same time. If you're a covered property, you can't charge a late fee. If you have a late letter that you use in your regular operations and it says your rent is late and you're now being assessed a late fee in accordance with your lease, and that is blank dollars, you can't say that to them anymore. You can't use that same letter this month legally, because there's a provision, if you've ever taken my Fair Debt Collection Practices seminar, there's a provision in the Fair Debt Collection Practices Act that says that if you are a resident, you are not allowed, if you are a debt collector, if you are the owner of or manager of a property that is collecting debts from residents like rent, like late fees, you can't ask someone to pay a debt that is bigger than what they owe, or a debt that is something that you are legally not allowed to charge. And that prohibition comes into play here, square on point. you are now illegally charging late fees. You are now illegally trying to collect late fees by sending a letter that says you want the resident to pay them to you, when federal law says you can't charge those. So if you don't change your late letters and you are a covered property that's subject to the moratorium, you have a Fair Debt Collection Practices Act problem just waiting around the corner. If someone found out about that and they were a creditor's rights lawyer, they very well might claim that you're violating federal law and are subjecting yourself to liability under the Fair Debt Collection Practices laws. So it really is super important that you recognize that and you make arrangements to change your late letters. Whatever you're communicating to your residents, if you're a covered property, has to be vetted through your lawyers, whether in-house or outside, to make sure that it isn't overstepping the bounds that are allowed under the laws. Another piece of the puzzle is, we've got lots of late letters out there that might say something about, if you don't pay, then we're going to refer the matter to our eviction attorneys to prepare and file a lawsuit against you. Well, if you're on a covered property, you can't do that either for 5 more months. And so threatening to do it today or next month or in June is wrong, because it's a threat that would be unfair to the resident. The Fair Debt Collection Practices Act is designed to force you to engage in practices that are fair. Threatening an action like having your lawyers file a lawsuit that you are legally prohibited from filing until August 27th is not an acceptable practice during the time that we have this moratorium in effect. So you need to consider whether that needs to be revised in your late letters as well. If that's a standard part of your practice, you may very well need your lawyers to help you balance the competing interests of this statute and the Fair Debt Collection Practices laws to make sure that you're not threatening people with actions that you can't take. Again, that only applies if you're a covered property, but that's most of you. So be mindful of how those resident communications can impact you. If you send second late letters, or if you send eviction warning letters or things of that nature, those are seen in by our clients periodically. Those are things that you need to have examined. Can you even send them anymore? Can you even send an eviction threat letter? Probably not. What does your second demand letter say if you send more than one? Those are all questions that you want to make sure you're revisiting in light of these prohibitions. The moratorium means you can't charge can't charge late fees and you can't file evictions. So you need to make sure that your communications to your residents don't tell them that you're going to charge those things, even if it's a typo, even if it's an oversight. If your letter says you now owe a late fee, that's wrong. And fair debt collection laws could be used against you in those circumstances. So be very mindful of what you are telling your residents in those communications. Okay, on to 5, evictions. Now we're in my wheelhouse. We highly suggest you contact your local attorney. Well, good job. You've already followed that. You've signed up for this seminar. Great work. Before you decide to initiate an eviction action against a resident in the current environment, as overlaying federal, state, and county laws or restrictions on the judicial process may apply. So by overlaying, he means not only does the CARES Act come into play, but also other things like the order issued by the Chief Justice of the South Carolina Supreme Court that closes the courthouse to basically all new eviction filings until at least May 1st. That's an overlaying state court issue that you need to consider when deciding what to do about eviction filings. For right now, unless you have a very special or unique circumstance that is supported by some sort of police report that necessitates immediate action at the courthouses are not considering new evictions at all, no matter what the reason, no matter whether or not you're covered by the moratorium in South Carolina until at least May 1st. So that's another problem. Even though my advice to you just a minute ago was start getting good at filing for evictions that are for reasons other than non-payment of rent. In South Carolina, you still have to wait a minute before you can do even that, unless it is a super critical crime-related eviction that needs to happen due to the pressing immediacy of the criminal activity, supported by a police report, an arrest record, something like that. You're going to have a hard time getting any case into the courthouse until May 1st. But for that limited segment, we are still trying to get courts to file those when they pop up. In the last few weeks, we've done a couple. We had one that just popped up today. And so we're hopeful that that will still continue to be part of the process. But consult with your attorneys to make sure you know what to do and how to do it. Whether you're issuing a notice to vacate, whether you're initiating the eviction-related action at all, whether you're assessing fees or penalties on residents for non-payment of rent or other lease violations, those are all things you want to make sure that you've got good guidance on before you do them. have your protocols reviewed by counsel. If not your own company's in-house counsel, then outside counsel. Dealing with evictions, there's a couple of pieces of the puzzle. In one of our earlier seminars, we talked about a March 25th notice from the Federal Housing Finance Agency, FHFA, that they brought down on March 25th, 2 days before the CARES Act. Owners of multifamily properties backed by Fannie Mae and Freddie Mac mortgages would be granted mortgage forbearance relief. In exchange, they would have to place a 90-day hold on evictions. Well, that guidance was incorporated into the CARES Act. That actual same guidance turned into Section 4023 of the CARES Act, which is one section before the one we were reviewing before. Section 4024 is the moratorium section. Section 4023 is the multifamily mortgage holder properties opportunity for mortgage forbearance that allows them to seek up to 90 days of mortgage forbearance. But we didn't talk about that today because we want to focus more on the collection issues and rent and evictions than on that. Then on March 27th, as we talked earlier, President Trump signed HR 748, the Coronavirus Relief and Economic Security Act, the CARES Act, into law. It includes a provision that allows owners of properties that have federally backed multifamily mortgage loan to seek forbearance because of financial hardship during the emergency for up to 90 days. That's in Section 4023. That provision also prohibits issuing a notice to vacate or initiating an eviction filing or assessing fees, penalties, and other charges on residents for non-payment or late payment of rent during the forbearance period. Additionally, a multifamily borrower that receives forbearance under the section may not issue a notice to vacate until after the expiration of the forbearance or require a renter to vacate until 30 days after that's been issued. Same provision that we generally talked about. But it also relates to the forbearance period. So a lender is allowed, or sorry, a multifamily mortgage holder is allowed to seek forbearance at any time during the 120 days. And so it may last longer than 120 days. If the mortgage on your property was current for the next 3 months, but during the last 2 months of the moratorium, you wanted to get forbearance, then you wanted to get all 90 days that you're entitled to, technically speaking, this provision would say that if you started your forbearance on July 1 and you asked for 90 days of forbearance, then you would have to continue providing forbearance to your residents by not charging late fees and not evicting them during your whole 90 days of mortgage forbearance, which could then last July, August, and September. That's why these two provisions are in there. But essentially, they say mostly the same thing. Separate and apart from the forbearance requirements, the CARES Act also creates a temporary eviction moratorium. We talked about this earlier. That applies to covered dwellings and covered properties. The mandate prohibits issuing notices to vacate, initiating eviction filings, or assessing fees or penalties on residents for non-payment of rent. And you cannot issue that notice to vacate again until after the expiration of the moratorium. So the moratorium itself applies to, for sure, rental housing providers whose properties are insured, guaranteed, supplemented, protected, or assisted by HUD, whether the FHFA, Fannie Mae, Freddie Mac, or participates in any of the following government programs: supportive housing for the elderly, housing for persons with disabilities, housing opportunities for persons with AIDS, the McKinney-Vento Homelessness Assistance Program, Section 236 properties, the Section 221 Below Market and Reduced Interest Rate Program, the BMIR, Section 8 Housing Choice Voucher Program, Section 8 Project-Based Housing, Home Guarantees, Rural Housing Assistance Programs, and Low-Income Housing Tax Credit Properties. So note in there, in the middle of that, there's a Section 8 Housing Choice Voucher Program. So if you have a dwelling that is receiving a Housing Choice Voucher Program assistance, you also need to treat that dwelling, even if your property is exempt overall, that dwelling for sure needs to be treated as though it is covered under the Act because of the Housing Choice Voucher payment that you receive from the federal government for it. So just be mindful of that. That may be a one unit exception. Your property may not be covered by the moratorium, in other words, but if you have a voucher holder or 2 or 3 on that property, you may have to treat those as covered dwellings and treat them as not exempt from the moratorium and subject to the moratorium. NAA recommends that you should communicate to residents. When people ask me, what should we be telling our residents? One thing that you can tell them, and NAA recommends it here, is you should communicate to them that even if you are a covered property under the CARES Act and you are subject to the moratorium, that 120-day eviction suspension in no way removes a resident's responsibility to pay rent or comply with the terms of their lease. In fact, Congress, 2 days after they passed the law, Congress actually put out an FAQ that directly addresses this, and the chairperson of the committee made a point of saying exactly this, that this act, the moratorium, is in no way intended as a rent forgiveness program for residents. It is simply designed as an enhancement for the protections that the government wants to give to everybody during this time of crisis. But it is not a handout. It is not a free pass. It is not an absolvement of their obligation to pay rent. Bear in mind that states and localities continue to push their own eviction moratoriums applicable to all privately owned housing. Nationally, at least 95 jurisdictions have announced eviction moratoriums in light of the spread of COVID-19, with more considering legislation or mandate by judicial action or law enforcement as we speak. So there's still possibilities that this may apply into the future. For example, in North Carolina, our courts are not holding hearings until after June 1st at the earliest now. And so if you have an eviction case, you can't get it heard before June 1st. Even if you have a criminal activity issue, you likely aren't going to get a hearing in North Carolina. In South Carolina, the same principle applies. They're not having hearings until at least May 1st. So even if we can get an exception for a unique criminal situation and we get an eviction action filed, it's still not going to be heard until the Supreme Court lifts the order imposing a moratorium on hearings through at least May 1st. So all of those sorts of things are applicable and need to be mindful. One thing I wanted to mention that I think someone had brought up is collections on past due balances. So the prohibition in this act doesn't have anything to do with collections activities. The moratorium applies only to charging late fees, only applies to instituting new eviction actions for non-payment of rent, but it does not in any way address or apply to otherwise modify your normal collection activities, whatever they might be. So the Fair Debt Collection Practices Act, again, still applies in many respects, but there's nothing in the CARES Act that limits your ability to utilize the collection methodologies that you use on a regular basis. The only thing that you can't do is charge late fees, and you can't initiate eviction filings to recover possession of the premises. But everything else is still business as usual. The statute didn't change that. And then lastly, I think, well, there's a couple of things, 6, 7, and 8. Resident resources is 6. In times of uncertainty, residents may need resources to help them through hardships. It's recommended by NAA that your community have a list of local and national resources that may help aid people in these circumstances where it's feasible. National organizations like the Salvation Army, United Way, American Red Cross may have assistance operations. Local departments of social services and local religious and charitable organizations should also be researched and shared to the extent that you can band together through the CAA. There are resources clearly within the community of the association where you can share information and solicit information like this that can be readily shared with your residents to try and help them out. Again, if there are local aid organizations, local churches that people know of that are willing to help people, you want your residents to be in touch with those places because their money is green, just like the residents' money is. And it doesn't matter to you where the money comes from, as long as you can get the residents the assistance they need, they're able to pay you. That's better for you and for the resident. So don't be shy about providing residents with opportunities to get help from aid organizations, especially local ones. Although not directly related to rent collection, additional resources should be shared, like organizations that can assist with foods, utilities, unemployment claims, and other essential items. It doesn't have to just be local churches that can pay some of your rent. It can be any number of other things. Local churches that can help your kids who are out of school by providing hot meals and things of that nature. Those are also helpful items for you as a community to keep in mind and share with your residents if you know of them. Many of these organizations may not be able to assist depending on a variety of circumstances, and any resident communications along those lines should avoid making promises, but sharing the opportunities is what you want to be engaged in. You want to be part of the solution, not part of the problem. Item 7, renewals. For leases that you have that are ending during this 120-day moratorium, which is going to be many, you may want to consider if a short-term lease or even month-to-month leases are an option to assist residents that may not have the financial means or the flexibility or the certainty to be able to commit to a long-term lease. You don't want people leaving when their leases run out because they're not sure how they'll be able to survive the next 12 months. Maybe it would be better to consider having a lot more flexibility about letting people go month to month, not charging them month to month fees for the time being. If they're paying their rent, why run them off with month to month fees? You know, if you understand that this is the reason, there's no reason that if this is the reason for their uncertainty, and you know that there's hopefully going to be a finite window of time where this COVID is going to apply, why not consider making a temporary change to your policies that allows for continued month-to-month tenancies with no penalties, no charges? If they're willing to pay the rent, that's better. You know, don't worry about whether you're getting month-to-month fees or not. Worry about, I'm getting full rent. These people want to pay, but they're not comfortable signing a renewal right now. I'd still rather get their money than run them off with month-to-month fees that they can't pay. So things like that are definitely ones you should be considering. Alternate lease arrangements, in other words, when you have a renewal coming up. Setting renewal increases may not be the best strategy for communities where occupancy could be an issue because of future vacancies too. Again, if your normal policy is to renew people and you have a predetermined amount of a rent increase, probably a good idea in this context to not be tone deaf. Rent increases in a time of crisis when you can't get your rent in the first place aren't really a good idea. Not likely to be productive. Certainly not likely to help you keep your property fully occupied during the next 5-6 months. So keep that in mind in terms of what your policies are and set them accordingly to try and maximize your opportunities to really get what you're looking for. And then lastly, payment incentives. Residents that have the financial capability to pay their rent on time may be encouraged to do so if there's an incentive available. Some companies are offering enticing options like gift cards to local business, a future discount or special offer that will take place once the pandemic is over. You're not allowed to charge late fees, but you are allowed to incentivize people who pay on time. And so again, that's something that you may very well want to think about. You don't want to get into the business of providing rent discounts because that could easily be construed as a late fee for everyone else who isn't paying on time or is unable to pay on time. You don't want to have that issue come up. But again, things like offering gift cards, giving people benefits that are not related to the rent itself, but that are thank yous for paying rent on time so that it helps your budget, helps you do your numbers better, and helps your cash flow go better. We think that that's a worthwhile consideration, and NAA put that in here to remind people that, you know, getting people to pay promptly by incentivizing them a little bit might be worth the gift card spend to get the money in the door with less effort. So think about things like that when you're developing your own plans. And then lastly on this form, there's related links and forms. We talked about them earlier. There's the form for payment plan agreement and a notice of temporary waiver of late fees that you can get when you look at this form. There's a listing that they keep of court closures and restrictions at the NAA website. And then there's also a link to the March 23rd Economic Impact Report that NAA prepared. If you're viewing these forms online on NAA's website, you'll be able to see those things.
Okay, Chris, we have a couple questions. If you want to field these real quick before we go. One of them, one of them was right there, what you were talking about near the end about the renewals. So if they don't, are they required to offer an extension? And if not, can they evict a holdover?
So the prohibition on evictions only applies to non-payment of rent. And so in theory, holdover tenancies are not non-payment of rent. And if you are changing your policy universally across the property so that you're no longer offering renewals or doing it on a different basis, you could in theory do that. The problem you have is a fair housing one. If you are singling out certain people for this protocol where you're not renewing them and then seeking to evict them for holding over, you could easily run afoul of the fair housing laws by doing a less than one-size-fits-all approach. As with most fair housing things, if you single out a particular tenant or a particular unit for special treatment that the other people don't get, then that is a ripe opportunity for a claim of discrimination to occur. So I think if you were going to consider that, it would be very wise to get with someone like Thomas Howard before you actually thought about doing something like that, because the change in your policy would need to be scrutinized to make sure that you're considering the Fair Housing Act appropriately. But,
and offering an incentive to pay rent wouldn't be fair housing violation because it could be considered a penalty to other residents?
It's not. You're incentivizing prompt payment by rewarding people who pay on time. So it doesn't apply. It's not being offered to certain residents and not others. It's just being given as an incentive to the people that pay on time. It's not a fee. It's not a charge being levied to people who pay late. And that's why it's so valuable, is that you can't communicate with residents who are paying late by charging them a fee under the moratorium. But you can provide incentives for people that pay on time.
We got two questions that are almost the same. I'm going to read both of them just in case. Does it change or modify the way to handle skips during the moratorium if they give COVID-19 as the reason? And then the second one that's similar, if someone surrenders their apartment due to COVID-19, can we follow the same policy for charging reletting and early termination fees?
So people that move out during their lease term, the same rules always apply. And whatever you can do, you're allowed to keep doing. There's nothing in the moratorium that prohibits that. If people move out early and don't fulfill their lease term, then the protocol 2 months ago is the same as the protocol now. What you were legally allowed to do under South Carolina law in February, you are legally allowed to do under South Carolina law today and during the moratorium. Yes. What that is and how to handle it, those are all fact-specific inquiries that you're going to want to get advice from your attorneys on when you're trying to deal with those facts and circumstances.
Okay, last question before we wrap it up. Does this also apply to new move-ins that are getting ready to move in? In other words, how are we protected against someone that wants to lease this week or next? They pay the prorate and then they stop paying their rent.
Nothing protects that. If your property is a covered property under federal law, then you are just going to have to live with that as a possible outcome. If they don't pay you when they move in and they don't have their prorated rent when they move in, then you don't have to give them the keys to the unit. That's always a transaction. Don't move people in unless they've given you payment. But sadly, if they move in and they pay you with a bad check, then you may be in the worst of all situations, which is you never got a nickel for the tenancy, even from the day they moved in, and you're not allowed to evict them for 5 more months. That is the granddaddy of all of the screw jobs that this law could put in place. Someone who bounces their move-in payment, their move-in prorate, you're not going to be able to remove them because of that for 5 months.
Gotcha.
And there's nothing we can do about it.
Okay, that was all of the questions. Thank you. Thank you very much for your time today. I know you're busy. Thank you everybody for attending. Just as a reminder, the links are available in the group chat right now if you want to copy and paste those before you close out the webinar. And they will also go out via email from Katie later today, along with a link to the video that we recorded. So if you need any of that, just keep an eye on your email over the next few hours. And then we'll also post it all on our YouTube page. Just search for Loebsack and Brownlee on YouTube and you should be able to find it there. Thank you, everybody.
Thanks, Michael.